law students, this is Jonathan Lipson with The Real Deal on Contracts. Today we're going to talk about the social control of contract through condition-based defenses to enforceability. If you're in my class, this corresponds to unit number 21. We'll really just break this down into two parts. Number one, I'll describe what I think is the general pattern in these cases. And number two, I'll march through some of the main examples. Try to highlight some of the high points. So first, what's the general pattern here? Well, I think there are sort of three steps. First, we're looking for instances where the capacity of one of the parties to the contract is somehow impaired in a significant way. For example, through mental illness, through intoxication, through infancy, through duress, and so on. In all of these cases, what capacity is referring to is the ability to form a meaningful assent to the contract. So the kind of defenses that we're talking about are typically defenses to formation. Where you have an effective, incapacity defense of some sort, we say that the contract is voidable. That's the second step in it. Voidable means that the contract can be enforceable or not at the election of the incapacitated party. It's in effect giving them an option to go forward or not. Now, obviously, somebody who's truly incapacitated will have a guardian making that decision. But you can also have people come out of whatever the incapacity was. You can go from being a minor to being an adult and ratify the contract, for example. The third step is to think about the issues that are most likely to arise here. And there are, I think, two. The first is the condition-based defense linked to the other party's knowledge of the incapacity. Sometimes it is, sometimes it isn't. Second, how much unfairness to the other party will we tolerate? Right? One of the things you should see here is that society has said, well, there are contracts that we're not going to enforce because we're concerned, in effect, about the true capacity of one of the parties to form the will or intention to, engage in meaningful promissory behavior. Police those contracts, we won't enforce them. On the one hand. On the other hand, that can be sort of unfair to, the other party, especially if they didn't know about the incapacity. So we're trying to balance those two sorts of things. All right, that's the general pattern. Let's turn now to the some of the main examples. First is mental incapacity. Restatement section 15 says that a person incurs only voidable contractual duties by entering into a transaction if, by reason of mental illness or defect, A, he's unable to understand in a reasonable manner the nature and consequences of the transaction, or B, he's unable to act in a reasonable manner in relation to the transaction, and the other party has reason to know of the condition. Again, this distinction between the other party knowing and not. Part 2 of section 15 says where the contract is made on fair terms and the other party is without knowledge of the mental illness or defect, the power of avoidance terminates to the extent that the contract has been so far performed in whole or in part, or circumstances have so changed that avoidance would be inequitable. In that case, a court may grant relief as justice requires. So again, this is, I think, the fullest example of this effort to balance protection for someone who might be incapacitated versus unfairness to the other party who might have relied innocently on the belief that the incapacitated person in fact had capacity to do the deal. Example number 2, intoxication. Section 16 has a somewhat similar pattern for intoxication. If the other party has reason to know by reason of intoxication, then the intoxicated person may be able to avoid their contractual duties. Notice from the Harlow case, it's just a note case, that you can have a lucid interval in an extended period of intoxication, and still intoxication can be a defense. Number 3, infancy. Right, I think we all kind of know that kids are not going to be held legally accountable for the contracts into which they enter. Those contracts are voidable. There's an exception for what are called necessaries. I think it's sort of an ancient doctrine from the 19th century. Things that were necessary for the health, etc., of the family, and which were purchased by a minor, would be that would in fact create an enforceable contract, notwithstanding the minority or infancy of the child. One way that we talk about the avoidability of contracts to which there's a defense like infancy is through rescission. So the effect of avoidance is the same as rescission, and you see that happening in the Haldeman note case, where somebody sold a car to a kid changed his mind, rescinded, seller had to give the purchase price back, and notice had to give the purchase price back even though the kid had trashed the car. That might seem to you unfair. Courts didn't seem to think so, and so one of the things we want to think about is, well, why wasn't that unfair? Sometimes students say, well, what if you use a fake ID? Not that any of you would ever do that, but what if the kid uses a fake ID? Shouldn't change the contract outcome, but of course the kid might be liable for fraud or something like that. So it's not not a great idea. Number 4, duress. Duress is essentially the idea articulated in Restatement Section 175 that if assent is induced by an improper threat that leaves the victim no reasonable alternative, the contract will be voidable by the victim. This obviously raises questions like, well, what sorts of threats are improper? What does it mean to think you have no alternative? And so on. We have 2 main cases on this, and it'll be important to kind of try to think through the pattern. One case, Mitchell versus CC Sanitation, the defense is effective. Mr. Mitchell was under duress and was able to get out of the deal. And in Selmer v. Blakesley, the defense was not effective. As I think Judge Posner says there, the fundamental issue in a duress case is not really the victim's state of mind per se, but whether the statement that induced the promise is the kind of offer to deal that we want to discourage and we therefore call a threat. I think one of the things that's concerning Judge Posner there is that we really can't know the subjective state of mind of parties. We don't know how intimidated or not somebody will be. And of course, if you think about bargaining, especially, contentious negotiations, there are going to be lots of threats going on. So it can't be the case that all threats are duress. But some are, and then the tricky part is figuring out, well, which are so bad that they produce avoidable obligation, one that's not enforceable necessarily. 5th, undue influence. This is a little bit like duress in that it's sort of a significant imbalance of will or power, but maybe not as much as in duress. And instead, what you find is a concern about the misuse of a special position of trust or dependence, where one person is taking advantage of the weaker or more dependent person. This is, I think, a common problem when you have contracting with elderly people, and given the fact that demographically we're going to see a large bolus of elderly folks kind of come through over the next 20 years or so, this is probably going to be a problem of increasing significance. That is the real deal on condition-based defenses to the enforceability of contracts.